Joining claims and parties. So a permissive joiner, under permissive joiner, plaintiff seeks to join non-parties as co-plaintiffs or co-defendants. Joining additional plaintiff relies on their willingness to join. So a non-party that plaintiff seeks to join as a co-plaintiff must agree to join. Joining additional defendants. This lies in the hands of the plaintiff. Non-party that plaintiff seeks to join as a co-defendant cannot refuse. Requirements. Permissive joinder is allowed where both 1, the same transaction or occurrence, so joined parties assert a right to relief arising from the same transaction or occurrence as plaintiff's claim. So defendant may be joined if the right to relief asserted against him arises from the same transaction or occurrence. 2, common question of law or fact. There is a common question or law or fact in the joined party's claim or claims against them. For example, after a bus accident, all injured passengers and bystanders join as plaintiffs. Common issue is driver's negligence. Other issues are tied individually for each plaintiff. Jurisdiction. Court must have jurisdiction over joined parties and claims. Note, we distinguish this from Impleader, which involves joiner of non-parties by defendant, whereas permissive joinder involves joiner of non-parties by plaintiff. Compulsory joiner. Absent parties may be forced to join a case if they are deemed necessary parties. Named defendants threaten dismissal for failure to join a Rule 19 party. So necessary parties, absentees are necessary when either A, without absentee, court cannot grant complete relief. Consider whether multiple suits might follow if absentee is not made a party. B, absentee has legal interests that may be impaired or impeded. Or C, absentee has an interest that creates a risk of multiple or inconsistent rulings and obligations. The test is not whether the joiner would be efficient. Joint tortfeasors, for example, are not necessary parties. The requirements are that absentee can be joined as a necessary party if 1, there is PJ over the absentee, and 2, joining the absentee will not destroy diversity. Indispensable parties. If a necessary party cannot be joined, ask whether the party is so indispensable that the case should be dismissed. Courts look at these factors. 1, is there an alternative forum available? 2, what is the likelihood of prejudice to the parties or others if the case goes forward? 3, can the court shape potential relief to avoid prejudice? And 4, would plaintiff have an adequate remedy if the case is dismissed? So for an impleader allows defendant to join a non-party who may be liable to defendant for all or part of the claim brought by plaintiff against the original defendant. This allows defendant to assert claims for indemnity, contributions, etc. against another party for the claim defendant is defending. Contracts and laws can create these rights of reimbursement. Your auto insurer promises to reimburse you if you can cause injury and are sued. Effect and terminology. Original defendant becomes plaintiff when newly joined party is a third party defendant. Original defendant becomes third party plaintiff. Requirement. Defendant may implead a third party defendant by filing a third party complaint within 14 days of serving her answer. After 14 days, defendant must get permission from the court. Defendant's claim under Impleader must be derivative. So the defendant / third party plaintiff cannot claim that third party defendant is solely liable to plaintiff, and Impleader thus should evaporate once the original plaintiff claim against defendant fails. Under jurisdiction, court must have personal jurisdiction over impleaded party. Court must also have subject matter jurisdiction and will generally have supplemental jurisdiction. Additional claims involving third-party defendant. Once third-party defendant is joined, third-party defendant may make claims of her own against other parties as long as subject matter jurisdiction exists over the claim. Original plaintiff may assert claims against third-party defendant arising from the same transaction or occurrence as plaintiff's original claim against defendant or third-party plaintiff. Intervention. A non-party absentee may seek to join or intervene in an already pending suit, either as a plaintiff or defendant. Intervention as a right must be allowed if either A, absentee's interest will be harmed if not joined, and no existing party will adequately represent that interest, or B, absentee has an unconditional statutory right. Permissive intervention is allowed in the court's discretion if either A, absentee has a claim or defense that shares a common question of law with the underlying action, and B, absentee has a conditional statutory right, or C, absentee is a government officer or agency and an existing claim or defense relates to the officer or agency or statute, regulation, etc. Court must also consider whether intervention will unduly delay or prejudice adjudication of original parties' rights. Jurisdiction. In diversity cases, interveners must establish independent subject matter jurisdiction. Supplemental jurisdiction will not cover diversity intervention. Intervention versus compulsory joinder. Compulsory joinder forces absentee into suit. Narrow must be very necessary for the court to force an absentee into a case. Intervention lets absentee join suit voluntarily and it's more lenient. And then there's interpleader. So interpleader allows the property holder to initiate a suit to compel multiple complaints to that property to litigate a dispute. So an interpleader is allowed under both federal statute and Rule 22. Property holder is the stakeholder. Other parties who want the property are the claimants, and the stakeholder plaintiff may also name itself as an adverse claimant defendant. Rule 22 interpleader. Complete diversity is required. Stakeholder must be diverse from all claimants. Amount in controversy must exceed $75,000. Subject matter jurisdiction, PJ, and venue requirements are all the same as for any other federal case. Statutory interpleader. Diversity requirement. One claimant must be diverse from at least one other claimant. So the amount in controversy must be $500 or more. Nationwide jurisdiction. Service is proper on anyone in the U.S. Venue is proper in any district where any claimant resides. Example, deceased had life insurance policy with DE Corp, with a Delaware Corp, having a principal place of business in California. Claimants from New Jersey, Nevada, and California all claim interest. Rule 22 interpleader improper because of the lack of diversity. So statutory interpleader, proper because claimants are from different states.